Welcome to The Ethical Advocate for Accidents.
Hello and welcome back to The Ethical Advocate for Accidents with James K. Sadigh. James has spent more than 35 years representing injured Californians in personal injury and insurance claim cases. Known for his balanced, transparent approach, he helps clients understand every option from settlement to trial so they can make confident decisions about their recovery. My name is Kevin Rosenquist, and today we're unpacking how experienced attorneys decide whether to settle a case or to take it all the way to court. James, welcome back.
Nice to be here again.
So when a client first comes to you after an accident, how do you start assessing whether their case is one that's likely to perhaps settle quickly or could end up taking longer and going to litigation?
Well, it's actually very difficult to assess that at the beginning. However, if the case does not have severe injuries and it's rather a smaller case, the likelihood of it getting settled is more than going to litigation. If the client walks in and only has what we call in our trade a soft tissue injury, a little pain and stiffness in the neck and back, it's more likely you can talk into a settlement than end up in a litigation.
Mm-hmm.
However, surprises are always up. For example, I had a case years ago that a husband and wife walked into my office. The wife was complaining of severe pain, could barely walk. And the husband, like a macho man, "Oh, I'm okay. I'm fine." Well, 3 months later, the wife was jogging and had no problem whatsoever. And the husband was having difficulty, having severe numbness in his fingers, could barely walk. And after the MRIs were taken, we found out that he actually has 2 levels of very bad herniated disc in his neck and low back. And after several months of going back and forth with different treatments and examination, he actually became a surgical candidate. So it is very hard to assess because the wife's claim in reality did not worth more than $10,000 or $15,000, which could be settled easily.
Sure.
And the husband, who thought that there's nothing wrong with him, ended up staying in the case for 2 years, going through all of the levels of discovery and litigation and depositions and medical assessment. And his case was finally settled in high 6 figures just when we were about to pick the jury. So it's very hard to assess.
I bet that happens often, where it settles right before it goes to trial if the insurance company realizes they've been beat.
Yes, it actually, majority of cases ends up settled. But usually what happens is that if they know the attorney, if they see the attorney is ready to go to trial, they take it a lot more serious, rather than just posture. And a lot of it has to do with the fact that during the time that you are doing what we call discovery, which is exchange of information between the plaintiff's attorney and the defense attorney, they see that you up to date with all of the information. They see how you give the responses. And one other thing that I've noticed is that a lot of plaintiff's attorneys, in my opinion, that's only an opinion, make the mistake of trying to keep the evidence away from the defense. And if there is a question, they always say objection and try not to produce it. So my question to those lawyers have always been, how do you expect the defense to know the value of your case and know what you have, what kind of evidence is in your hand, so that they could advise their side that they better settle or what the value of the case is? So it is very important to always have the communication.
For listeners who might picture fighting as the only path to justice, what are reasons that an attorney might perhaps try to strongly recommend settling instead?
Well, a lot of it is actually about the money. One of the best things that I can always tell the people is that our legal justice system in a civil system is not necessarily designed to get to justice. It is designed for people to find out about each other's cases and hopefully try to resolve it amongst themselves. Because once you put it in the hand of the 12 people, you don't know what kind of prejudices and the experiences they have that is going to affect their judgment on your case. I usually start by telling them a joke, which is based on a movie that Marx brothers had made, where one of them, Groucho Marx, was arrested allegedly for a murder, and the judge tells him, well, if you confess, the district attorney is going to give you a deal. And Groucho says, under no circumstance, I haven't done the crime. I'm not going to confess. And the judge explains that if you get convicted, it's going to be for life. But the but the prosecutor wants to give you a deal. He says, no, absolutely not. I'm not confessing. So the judge calls the jury, says, bring the jury panel. And Mr. Marx turns around and says, the jury panel, what is that for? He said, well, since you're not confessing, we have to go to trial and the jury decides your fate. And all of a sudden, Groucho Marx says, okay, I confess. And the judge says, wait a second, you don't know what the deal is. He said, whatever it is better than me putting my fate in the hand of the 12 people who don't know how to get off the jury. Now, that is the joke.
I love the Marx Brothers. That's awesome.
I still believe that the best system of the justice that we have all over the universe is the jury system that we have here. And I still believe that the jurors make much better and fairer decisions than any one-man judge. However, the jurors come with their prejudices. Do they like the color of your skin? Do they like the sex and gender that you have? Do they like the type of work you do? Do they like your accent? How does your nose look on your face? All of those affect the jurors. And so you have to be mindful of that. And the other thing is money. Going to jury trial or any kind of litigation is not inexpensive. Every simple depositions nowadays cost $2,000. Paying the jury fees, each juror's $15 a day for the duration of the trial, all 14 of them, 12 jurors and 2 extras, cost money. The court reporter who sits there for the 3 to 8 days of trial and taking the notes costs money. When you want to put the copy of your x-rays, MRIs, or anything and hire your doctors and experts to come and testify, you have to pay up sometimes up to $7,000 to $10,000 a day.
Whoa.
All of those cost money. So that's why sometimes when you have an offer of settlement, you have to sit down and say, how much of this settlement will end up in my client's pocket? And if I go to court and get that extra $100,000, is it going to actually pay more to my client or not? That's where the ethics comes. Because if you get a bigger judgment, well, you as the attorney who gets a percentage of that judgment as your fees make more money. But is it ethical for you to make more money if the client is not making more money and goes through the trial? Those are the questions.
Okay, so then on the other hand, when there's a settlement on the table, but you might think that it's better to continue the fight, how does that kind of process work, and in what situations might you want to go down that path?
Well, first of all, you have to have a very strong belief and conviction that you can get a lot more in the trial than the settlement that is offered. And then you sit down with the client and you put a blackboard or a piece of paper and you go through both scenarios. And you basically say, if we settle today with this amount, this is how it's going to end up in your pocket. And if we end up in trial, I believe that we are going to get this much money, and this is the cost, and this is how much it's going to go through. And I think the difference of money is so much that it's better for you to make a decision to go to trial. However, I can never force a client. I will never lie to a client. And I can never guarantee what the jury verdict is going to be. I'm only telling them it's my opinion. And I will usually try to bring another colleague who's not in my office with the client and say, here's another opinion. And at the end of it, the client has to make the decision himself.
Mm-hmm.
But a lot of times, the cases also comes down to it is that the client says money is not important. It's the fact that I was treated bad.
Yeah. It's the
Well,
principle. Yeah.
that's the client's decision. Again, the insurance companies do not change their behavior because they lose one big case.
Mm-hmm.
Because for them, there are hundreds of thousands of cases out there, and they have their statistic. So that's another thing I have to tell them. You cannot change the insurance company's behavior, or you
Right.
think you're punishing them by doing that, by taking it to trial. Always think about yourself.
Yeah, that's a good point. People are thinking of the that's cool. I mean, that they want to, show the ills of society or whatever, and show how this is going wrong. But at the same time, you're not going to change. You're not going to. They've got so much money. You're not going to change their outlook on how they do business. But do you also find that sometimes when people might look at settling as either quitting or perhaps leaving money on the table?
Oh, yes, I hear that a lot. And again, I have to sit down and explain to them that they have to think at the end of the day, what is going to end up being for them. You can go to trial and get a big verdict, but what good would it do if end result of it is less money in your pocket for your pain and suffering? Again, this all comes down to this. When a client comes to me, aside from getting the proper medical treatment and having all of their out-of-pocket expenses paid for, they need to have some kind of a financial money come to them for the pain and suffering and emotional distress that they endured during that time. If you go to trial again, for example, and get $100,000 verdict and even collection, because of the cost of trial, because of the experts, because of the time that you put in there, and the client end up only with $10,000 in his pocket. Is that better? Or if you settle the case for, let's say, $65,000 before litigation, and the client ends up with $10,000 or $15,000 then in his pocket, 2 years earlier. All of this has to be assessed.
Mm-hmm.
But at the end, it's not about teaching the insurance company anything. They have all the knowledge. It's about what you can get for your client in the most reasonable time.
Mm-hmm. Do you, I mean, we all, well, I shouldn't say we all, but most of us watch some form of courtroom drama, TV, movies, whatever. Do you find that people come into it when they want to fight, when they want to go all the way to trial, that they have a lot of misconceptions about how that process actually works?
Absolutely. Absolutely. People genuinely believe a lot of things they see in the movies and series about the law practice. And what they don't realize is that they're watching a movie, which is hour and a half, or an episode of Law and Order, which is 45 minutes or 40 minutes, and they see the courtroom drama. They don't realize that it has taken probably 2 years before the case gets in front of the jury. And during that 2 years, many of the evidence have been developed, and a lot of the evidence have been ordered to be out completely in front of the jury. And a lot of those arguments that you see happens in a courtroom in the movies is not allowed to be done. It's only for dramatization of the episodes in the movie that they do that. Sure. And so the system is very different. And that's why I have to sit down with them and explain code of evidence and presentation of evidence to them all the time for them to realize what's real, what can be put in the court.
Mm-hmm. Now you said the majority of cases settle. What percentage roughly would you say go to trial?
Well, from the moment that the cases come to the office, I can easily tell you that about 50% of them doesn't even get to the lawsuit. The client finished the treatment and have all the damages. You send it to the insurance company, and you can actually have a successful negotiation for settlement.
50% of the time it goes that smoothly?
That's right.
Oh, wow.
Of the remaining 50% that you have to file a lawsuit because either the offer of settlement is not good or whatever is wrong with the case, again, by the time that you go halfway through the litigation, it takes about average of 2 years before the trial. About 65 to 70% of those cases get settled. Of the remaining 30%, I can tell you that only about 5 to 10% will end up in trial.
Mm-hmm.
They either are forced by the judges to go to some mediations or settlement conferences, and we have very good mediators and settlement officers in our court system in Los Angeles that are very helpful, and they can persuade people to look at everything logically and do it. So only 5 to 10% will end up in trial.
Okay. And you mentioned mediation. I was going to ask you about that because a lot of people don't understand how mediation works, and that it's, you have a mediator, but it's they're trying to get you to help reach a settlement. They're not a judge. They're not going to rule. They're not going to make a decision. Is mediation typically something that you find to be very successful?
In most cases, yes. But again, you have to be careful how to pick your mediator. Are these mediators people who actually have experience in the field that you go in front of?
Mm-hmm.
And also have to understand that the mediator's purpose is to settle the case. They don't care if the settlement is fair or not. They just want to get it settled. So again, it depends on your attorney and your advocate to be able to sit down with the mediator and push the mediator to go back to the defense and try to get more money out of it. People have to realize mediators come to our side and try to point the negative parts of our case to us in order to bring our expectations down. Mm-hmm. And then they go to the other side and try to tell them about the negative sides of their case so that they can extract more money out of them. Mm-hmm. It's your job to be able to help the mediator to go to that room and keep getting more money out of the other side. Mm-hmm. And good mediator can be very, very effective. But it's your advocate who has to know how to talk to the mediator and sometimes stand up to the mediator.
Mm-hmm. Yeah. Well, that was I've heard mediation can be something that is hugely helpful, and so one question I did have, if the mediation doesn't work and it still goes to trial, is anything from the mediation allowed to be introduced during the trial?
Generally, absolutely no.
Okay.
A lot of times under our legal system, any kind of a settlement conversation, whether with the mediator or without a mediator, is protected to be put in front of the trier of a fact to determine. That way, we have a policy in the state of California to let people freely talk about resolution and settlement without a fear that if at one point they said, I'll take $5,000 and go away, to be put in front of the judge or the jury.
Yeah, that's a good policy, I think, to keep that separate.
Absolutely, because then people in good faith will sit down and try to resolve their situation. By way of example, I was handling it. This one was not a personal injury; it was an employment case. My client wanted $1 million, but I knew that the case is not worth $1 million. It was a personal fight for him. It was an age discrimination type of case. After about 12 hours of mediation, I finally told the mediator, look, this man, after giving 35 years of his life to this company, was not treated correctly. All he needs is to hear an apology and an appraisal of the value that he had for the company. And when the mediator heard that and put that correctly in front of the defense attorney and the employers, half an hour later, we had a happy settlement for only $100,000. Because all my client wanted to hear was, we apologize. You were very important to our company. As a matter of fact, we're going to throw a nice luncheon and present you with a plaque that you were the best employee of the year for the company. And a lot of cases will resolve if the mediator is creative and if you know the psyche of the parties. And sometimes on the defendant's part, even the insurance company, sometimes the issue is not necessarily money. And you have to be very cognizant of that.
Mm-hmm. Yeah, you got to understand the case as a whole.
Correct.
Mm-hmm. All right. Interesting stuff for sure, James. Well, that's it for today's episode of The Ethical Advocate for Accidents with James K. Sadigh. If you've been injured and want straightforward, honest guidance from an attorney who personally handles every case, visit jamesksadigh.com. And please don't forget to subscribe to our channel and leave us a review. We very much appreciate it. James, really enjoyed the conversation. Thanks so much.
I appreciate the opportunity. Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.